Hello, my name is Richard Owen. I'm from the University of Glamorgan. And in this lecture I'm going to talk about breach of duty of care. So in previous lectures we've looked at the existence of duties of care, but the fact that duty exists doesn't mean there's a claim in negligence. That duty must be breached, and there must also be resulting damage. And here in this lecture we'll be looking at actual breaches of duty. Now the test in deciding whether it was a breach of duty was laid down by Alderson in Blythe and Birmingham Waterworks Company. He said negligence is the omission to do something which a reasonable man, guided upon the considerations which ordinarily regulate the conduct of human affairs, would do, or something which a prudent and reasonable man would do. So what's a reasonable man? Well, in the case of Hall and Brooklands Auto Racing Club, Lord Justice Greer said is sometimes described as the man in the street or the man in the Clapham omnibus, or as I've recently read in an American author, the man who takes the magazines at home and in the evening pushes the lawnmower in his shirt sleeves. The important thing to know about this is it's an objective standard. So we're not looking at an individual's idiosyncrasies. People are judged objectively in deciding whether or not they've behaved reasonably. The idea is everyone's judged by the same standards, with very few exceptions, and the only exceptions are experts, who are judged by a higher standard. There are special rules for children, and special rules for the mentally and the physically ill. So the fact that it's an objective standard can produce harsh results. So you take, for example, the case of Nettleship and Weston. Here we had a learner driver who caused an accident. The learner driver was judged by the standards of the ordinarily competent driver, which is someone with a reasonable amount of experience, or in other words, the defendant was judged by a standard that the defendant could not possibly meet, because the people are judged objectively. So you don't look at people's individual foibles, idiosyncrasies, you judge them objectively. But you take into a number of factors into account in deciding whether or not someone has behaved reasonably or not. So the first factor to take into account is there is no liability for unforeseeable harm. The law of negligence accepts that bad things will happen from time to time, and that no one is particularly to blame. It's not something that could have been planned for. It's an unforeseeable event, and therefore there is only liability if someone is at fault, because the law of negligence operates according to a fault principle. Now, the second factor to take into account is the magnitude of the risk. And all things being equal, you wouldn't expect someone to guard against a very small risk from happening. You know, some freak event, say a satellite falling from outer space and landing causing damage, you would not normally plan against such an occurrence, because the chances of it happening are so slim. So to give you an example how this works, the case of Bolton and Stone, and this case was to do with cricket. A cricket ball had been hit out of a cricket ground into a neighbouring lane. This had happened about 6 times over about 28 years, and when it had been hit out of the cricket ground into this neighbouring lane, the neighbouring lane was rarely used. So you would not reasonably expect someone to take protective measures against something that's happened about 6 times in 28 years, and when it does occur, even then the likelihood of harm occurring would be very small, because this lane was very rarely used. Of course, on the 7th time this was hit out of the ground, it actually hit the claimant, but it was held that there was no negligence in that case, because the magnitude of the risk was so small, the likelihood of any harm occurring was so minuscule, it was not reasonable to expect the defendant to take any measures to prevent this from happening. Now contrast that with a similar case of Miller and Jackson. Now here a cricket ball again had been hit out of a cricket ground, but this was happening about 8 times a season. So it was happening much more frequently than in the case of Bolton and Stone. So in that case it was held that there was a duty on the part of the defendants to take measures to prevent this from happening, and it was reasonable to expect it in that particular case. So you take into account the magnitude of the risk, the likelihood of the harm occurring. However, there are exceptions to this rule, and an exception would be in the case of Paris and Stepney Borough Council. You would take into account the severity of the damage that would occur, even if it was a very small risk. Now, the claimant in the Paris case, he started with one eye. He was working as a metal worker. A trip flew out, of course, went into his good eye, and he was rendered totally blind by the accident. Now, in that case, the defendants were liable. Even though this was a freak accident, it wasn't likely to happen. It was held that they had behaved unreasonably, even though it was a very small risk, because they said, well, although it was a small risk, the severity of the harm that would occur was so great that it was reasonable to expect the defendants to take precautions against it, particularly as the precautions taken would have been relatively cheap. If they just provided safety goggles, the harm would not have occurred. So if you balance the fact that although it was a small risk, it was going to cause severe harm if it came about, and it was cheap to take protective measures, then the defendant was liable. Now, another thing to take into account is the practicability of precautions. Has the defendant done all that was practicable in terms of preventing the harm? In the case of Latimer and AEC Limited, a flood had entered a factory, it had mixed with oil, made the floor very slippery. The defendant put down sawdust to prevent people from slipping. The claimant found a patch which had not had sawdust put down, slipped on this patch and broke his leg. And it was held in that case the defendant had done all that was practicable to avoid the harm, so had behaved reasonably and was not liable. Something else you can take into account is the object to be achieved, and we've had recent legislative enactment here. Section 1 of the Compensation Act of 2006 provides courts, considering a claim of negligence or breach of statutory duty, may, in determining whether the defendant should have taken particular steps to meet a standard of care, whether we're taking precautions against a risk or otherwise, have regard to whether a requirement to take those steps might A, prevent a desirable activity from being undertaken at all to a particular extent or in a particular way, or B, discourage persons from undertaking functions in connection with a desirable activity. In the background of the Compensation Act 2006, was obviously schools become reluctant in certain circumstances to organise trips and so on, and it's trying not to have the law in such an onerous state that it deters people from carrying out what would otherwise be desirable activities. Now, a leading case in this area is the case of Watt and Hertfordshire County Council. Now, in that case, they said you must take into account the object being achieved. The claimant was injured when heavy lifting equipment had not been securely fixed to a fire engine, and the reason it hadn't been securely fixed was because they were rushing to the scene of an accident and they needed to help someone who was obviously in severe distress and whose life was at risk. So you had to weigh up the fact that the time taken to secure the equipment and the risk that was entailed. If it was not secured, it was judged to be small. It was regarded to be judged to be particularly small in regard to what they were trying to achieve, and that was obviously rescue someone who was in a dire situation. So you should take that into account. Now, something else you can take into account is general and approved practice, because its normal rule would be if you're following the general approved practice, particularly for a type of professional activity, then that is strongly evidential of the fact that you have behaved reasonably and not committed negligence. However, there is an obvious folly doctrine that was first expounded by Lord Dunedin in the case of Morton and William Dixon. He said, where the negligence of the employer consists of what I may call a fault or omission, I think it is absolutely necessary that the proof of that fault or omission should be one of two kinds. Either to show that the thing which he did not do was a thing which was commonly done by other persons in like circumstances, or to show it was a thing which was so obviously wanted, it would be it would be folly in anyone to neglect to provide it. So that's the so-called obvious folly doctrine. I think the case, to my mind, that illustrates it most clearly is the case of Reed, the Herald of Free Enterprise. This involved a roll-on, roll-off ferry. Cars could roll on and roll off a ferry. It set out to sea from the port of Zeebrugge when its bow doors were still open, because the boatswain whose job it was to close the bow doors had fallen asleep. So the ferry went out to sea with the bow doors open. It let in sea, and eventually the boat capsized and several hundred people were drowned. Now the master of the ship said that he had not been negligent because he had not checked that the bow doors were shut, but he said it was general and approved practice, it was the common practice for merchant shipping of that nature for the master of the ship not to check that the bow doors were shut. Well, the courts accepted, well, that might have been general and approved practice, but the general and approved practice was so obviously flawed, it was such an obvious folly, that he should not have followed the general and approved practice. So he was still liable in negligence. So that's the general standard, that of the reasonable man. As I say, it applies generally. There are very few exceptions. And we'll move on to the exceptions. And the first exception are professional people, people engaged in a professional activity. Now here they are judged by a higher standard. In the Bolan case, it said that the standard they have to reach is the standard of the ordinary skilled man exercising and professing to have that particular skill. A man need not possess the highest expert skill at the risk of being found negligent. It is well established that it is sufficient if he exercises the ordinary skill of an ordinary competent man exercising that particular art. And that's become known as the Bolan test. So you must be an ordinarily competent man exercising that particular art. And again, that can work harshly in the case of trainees. Take the case of Wiltshire and Essex Area Health Authority. In that case, it was held that a trainee doctor was to be held by the standard of a reasonably experienced person. And by definition, a trainee doctor is not a reasonably experienced person. By definition, a trainee person is someone acquiring their initial experience. Nevertheless, because it's an objective standard, you don't look at the particular person, you judge people as much as possible by a common standard, and for professional people, it's of the reasonably competent person exercising that particular skill or art. So even if you can't meet that standard, by definition, still you will be judged by that standard. As held in the Sidaway case, there's a duty to inform a patient of risks, but subject to the doctor's overriding duty to act in the patient's best interest. However, there had been some concern about the Bolan test, and some concern about the Bolan test is that basically if a person has followed a body of medical opinion, if a medical professional has followed a body of medical opinion, it doesn't matter if there's a contrary body of medical opinion, that medical professional will not normally be regarded as negligent. Now the reason it was felt the need to refine the Bolan test, it was thought that the courts were ceding their power to the doctors and the medical professionals, because all you had to show was that there was a body of opinion. It was never really clearly defined what a body of opinion was, but if you could show that a body of medical opinion agreed with you, even if there was another possibly bigger body of medical opinion that disagreed with your course of action, then you would not be regarded as negligent. And the fear was that doctors were not being held to account for their actions. If you could just find any sort of body of a medical opinion, then you would not be regarded as negligent. So in the Blytho case, it was refined slightly, and in the Blytho case, they said a judge can choose between two bodies of medical opinion and could reject a medical opinion where the judge regarded that as legally indefensible. So it's legally indefensible, and the judge can actually reject that opinion. So far we've looked at the general standard by which so far as many people as possible are judged. and that's sort of the reasonable man in the Clapham omnibus. We looked at professionals, the Botham test, which sets a higher standard for professionals. Now we'll look at children with slightly different rules. Now in the case of McHale and Watson, the question was, well, had a 12-year-old child been negligent? And so in that case, you would look at the sort of the ordinary 12-year-old child. So it's made slightly subjective in that you would look at children of the same age, but then you would decide what would the ordinary 12-year-old child have done in those circumstances. Now, a recent case on children and breach of duty is the case of Blake and Galloway, and here children were engaging in horseplay. In a break in their music practice, they were throwing bark chippings at one another, and of course one of these chippings had to severely injure one of the children. So the question was, had there been a breach of duty in that case? And it was held for horseplay. There would only be liability and negligence for horseplay if it amounted to recklessness or a very high degree of carelessness. So an acceptance to quite a large extent that the children will engage in horseplay, and horseplay only becomes negligent when indulged in by children if it involves recklessness or a high degree of carelessness. Now, if we move on to the burden of proof and something called res ipsa loquitur, so as burden of proof is concerned, we're looking at law of negligence, obviously civil action, so negligence is determined on the balance of probabilities. Is it more likely or not that the defendant has been negligent? Now, Section 11 of the Civil Evidence Act of 1968 allows you to bring in criminal convictions in certain cases as evidence. So, for example, if someone was driving too fast, being convicted of some traffic offence, you could use that for some physical injury that has resulted as a result of the careless driving. Now I want to move on to res ipsa loquitur, or translated means the thing speaks for itself, because normally it's the claimant's job to prove on the balance of probabilities that the defendant was negligent. But if you can invoke the doctrine of res ipsa loquitur, that shifts the evidential burden from the plaintiff to the defendant. But the thing must speak for itself, so it must be something that would not normally occur without negligence, something that could only have happened if someone has been negligent. So what type of thing could only have occurred with negligence? Well, in the case of Chapronier and Mason, it was held that you don't find stones in a bun unless someone has been negligent. Or in Cassidy and Minister of Health, you don't find swabs inside a patient after they've been sewn up after an operation unless someone has been negligent. So it's the type of thing that can only occur if someone has been negligent. It speaks for itself that negligence has occurred. Now, it must also be something under the control of the defendant. So if someone falls out of a railway carriage on a long railway journey, as in Eastern and London North Eastern Railway, that could not be said to be under the control of the railway company because there was the opportunity for people to interfere with the train door during on a long journey. But contrast that with the case of G and Metropolitan Railway. Now in that case, someone fell out of a train very shortly after the train had left the station. So they said there it was held and it was under the control of the defendant because you would not fall out of the train so shortly after the station without there being some fault on the part of the defendant, and there was no opportunity for anyone else to interfere in that particular case. And also the third thing you look for before we can invoke the doctrine of res ipsa loquitur is that there's an absence of an alternative explanation on the part of the defendant. So if the defendant could come up with some plausible explanation as to how it could have occurred without negligence on the part of the defendant, then the claimant is back to square one and must prove on the balance of probabilities that it's that the defendant's negligence caused the accident. It wouldn't be enough there to reverse the burden of proof. So what is the effect of this? We're just talking here of an evidential burden being shifted from the plaintiff to the defendant. So you put in the onus on the defendant to come up with some explanation. as to how this could have occurred without negligence on the part of the defendant. It's not for the defendant to show that on the balance of probabilities he or she was not negligent. It's just a shifting of the evidential burden for the defendant to explain how something could have occurred without negligence on the defendant's part. And that concludes this lecture.